HIPAA Basics, Privacy, and Security for Ventura County Medical Association members and providers. HIPAA stands for the Health Insurance Portability and Accountability Act of 1996. The initial act had very little to do with privacy or security protections for patient information. Rather, it was about portability of health insurance and a plan to strengthen the COBRA benefits that applied to larger group employers to allow individuals who left the employee to retain their health insurance, albeit through paying their premiums specifically and directly to the health insurance plan. Part of the regulation required health insurance companies to provide this individual coverage. This was long before the individual mandate as part of the Affordable Care Act. The insurance carriers pushed back due to the cost and administrative burden of providing individual health insurance coverage and sending out premium notices and premium billing. There was a deal, however, that was created between Congress and the congressional committees and the insurance carriers to win their support to provide ongoing protections and movement of the HIPAA bill. This was to federalize and promote electronic health transactions. Examples such as healthcare claims, eligibility verification, payment or remittance advices, and areas related to the transactions and code sets rule. In fact, the rule even required the full adoption of things such as the CPT codes, ICD-9 at that time, now ICD-10, and standard transactions so that the entire electronic exchange of health insurance and billing related data could be made far more effective and efficient in the system. So how did this actually become a privacy and security regulation? While the stakeholders accepted the idea of promoting electronic transactions, in 1996, when this bill went into effect, there was very little in the way of protection for the security of electronic data that was moving over at that time very unregulated and extremely vulnerable internets and internet systems. And there was a great deal of concern that there were no standard privacy protections across the country. Out of these concerns, the Portability Act grew to also incorporate a privacy rule and a security rule. The initial group of covered organizations covered by HIPAA were the health plans, with exclusion of workers' compensation plans, but including Medicare and Medicaid, or in California, Medi-Cal. Healthcare clearinghouses, so organizations that process data elements or transactions, such as a clearinghouse that will take your electronic claims data from your electronic practice management system, convert that, send that on to the insurance carrier, and even electronically provide you the remittance advices and or explanations of benefits. And of course, the most important class, at least for Ventura County Medical Association, healthcare providers such as physicians and ancillary providers. Now, the definition, as you can see from the slide, is any person or entity that furnishes, bills, or is paid for healthcare and uses electronic means to transmit or receive any of the following, such as a health claim, remittance or payment advice, eligibility verification, claim status, referral authorizations, and so forth. These are considered electronic transactions and under HIPAA are known as the HIPAA standard transactions. So if you are a physician and you do not engage in any of these particular electronic transactions, HIPAA does not apply to you. However, California law protecting the privacy and security of data will apply to you. Are other kinds of organizations covered under HIPAA? Well, only what we've just described in terms of health plans, clearinghouses, and also providers. But there is another designation under HIPAA of an organization that is covered by HIPAA, and that is a business associate. A business associate is a very unique concept to HIPAA. It is only applicable in HIPAA, and it is an individual or entity that creates, receives, stores, maintains, or transmits protected health information disclosed to it by a covered entity such as a physician or a hospital for a function on behalf of that covered entity. So again, a business associate is either an individual or a company, an entity that creates PHI, receives PHI, stores PHI, maintains PHI, or transmits it on behalf of a covered entity. Business associates need to adhere to many of the same safeguards as HIPAA covered entities, but it is your responsibility as Ventura County Medical Association members who are participants in this program and have a business associate as a covered entity to ensure that they have signed your business associate agreement. Typical business associates for a medical practice could be your software vendors, like your practice management or your electronic health records vendors. It could be a medical equipment vendor where the medical equipment is storing patient data. It could be outside contractors like billing and coding companies or billing services and so forth. HIPAA became effective in 2003 in terms of the privacy rule. The transaction and code sets rule became effective in 2003 in the fall, and the security standards went in place in 2005. The rule remained fairly static for another 8 years until the major, what we call omnibus rule, the final rule that modifies Privacy, Security, Breach Notification, and Genetic Information Non-Disclosure Act. That rule was published and went into effect in March 26, 2013. Now that rule referenced the HITECH Act that was passed in 2009. And that HITECH Act applied to providing incentive funds and creating the environment for the adoption of electronic health records. So much of what was in the HITECH Act and things that were relevant for what we called meaningful use, now we call that promoting interoperability, were the core of what went into the changes in 2013 with the omnibus rule. So what does the privacy and security rule really require? The basic requirement is the safeguarding of individually identifiable health information. This is also called protected health information, or PHI, and that is the term we will refer to throughout the rest of this presentation. PHI is anything that relates to the health of an individual and can identify that individual. It can be a paper form, electronic or computer forms, or even verbal forms. And then, of course, there are state laws that in some cases may be more stringent than HIPAA. If they are more stringent than HIPAA, following those laws is called preemption under HIPAA. California is a very good example of having state laws that are more strict or stringent than HIPAA. So for example, California law requires providing patient access to their medical records in terms of certain formats like getting copies within 15 days, whereas HIPAA has a 30-day and then another 30-day extension to it. Or California has specific law for the age of a minor to consent to their own treatment. Compliance, ultimately, for a medical practice is to maintain written policies and procedures that are your guidebook and instruction book for how to follow and comply with HIPAA, providing patients or subject individuals with specific forms, and training. It's also handling complaints and incidents and correcting any compliance problems, being vigilant and aware to protect patient information, PHI, and staying current with the law. And definitely HIPAA is enforced. There are civil and criminal penalties. It is enforced by the Office of Civil Rights, can also be enforced by the California Attorney General, and can also be enforced by the Department of Justice. Criminal violations that are enforced by the Department of Justice will have typical criminal penalties or consequences. Penalties can be both civil or criminal. They have been applied. And you need to be very careful to always respond correctly to any enforcement request from the government or the Attorney General. Penalties will be applied based on the severity ranging from ignorance of HIPAA to reasonable cause or willful neglect that has been corrected or not corrected. Penalties start at $100 per violation, can go as high as $50,000 per violation. Many organizations have been fined and have had to negotiate settlements, specifically with the Office of Civil Rights, for HIPAA fines. So don't think that HIPAA does not apply and can't be enforced to even the smallest medical practice. So now let's look a little deeper into the HIPAA privacy regulation. Ultimately, HIPAA is about doing the right thing and doing things right with your patient's private information. One of the core concepts of HIPAA is to name a HIPAA privacy official. Now, please note, sometimes people will call this a HIPAA privacy officer. The actual appropriate definition, according to the HIPAA rule, would be to say HIPAA privacy official. An officer might indicate that that person is an officer, for example, of your medical corporation. In this case, the privacy official may not be a corporate officer. They might be an office manager or a compliance official or some other person that is not necessarily, perhaps it's your medical records person, not necessarily an officer of the corporation. The privacy rule requires safeguarding PHI. PHI is health information, including demographic info. So demographic info would be names, addresses, zip codes, things of that nature, which relates to the individual's past, present, or future physical or mental health or condition, the provision of health care to that individual, past, present, or future payment, such as claims that you submit or statements that you send out to the patient, payments that you receive, and that identifies the individual or for which there is a reasonable basis to believe can be used to identify an individual. To ensure that your PHI is not protected health information, you must ensure that 18 different identifiers have been properly stripped away. And these identifiers include the names, first, last, middle, nicknames, geographic subdivisions. Typically it can be a zip code or something smaller, any kind of a date, date of birth, date of death, date of discharge, date of service, telephone numbers, fax numbers, email addresses are considered PHI. So sending an email to a patient with nothing other than just the email address could be considered PHI, and if that is sent unsecured, could be considered a violation of HIPAA. Social security numbers, and then medical record numbers from your electronic health or practice management system, health plan numbers, the beneficiary numbers, account numbers from within your system, certificate numbers, and as you can see here, a whole lot of other kinds of numbers. So if you are in cardiology and you have implantable pacemakers, they have a serial number. Or if you have any other kind of implantable device with a serial number, that device number and serial number is considered a PHI element. And then full face photographic images or comparable images and other unique identifying numbers or characteristics. So pinning up a picture of a happy mom who just delivered a baby and a picture of the baby on your bulletin board, or posting that on your company, your practice's website without the patient's authorization would be a violation, because that picture is considered PHI. Covered entities like medical practices must constantly update their inventory of PHI to be sure that you know what you have and that that information is safe and secure. So for example, if you are participating in the Ventura County Medical Foundation's Accountable Care Organization and you are transmitting or sharing information with them for the clinical quality measures that incorporates patient data, then that would be an update to your internal inventory of another form of PHI. You've extracted it from your electronic health record. You're now uploading it into their systems, or they're gathering it on your behalf. That is another kind of PHI inventory. And remember, PHI can be in written, computer, or oral or verbal forms. A verbal form could be a conversation or discussion between a patient and a physician, or a patient's caregiver or guardian, or between the front desk and a patient. The privacy rule also enhances a patient control over their own PHI, and it creates a series of rights that patients have, civil rights, to the privacy and availability of their PHI that must be met by medical practices and covered entities. However, your efforts should always be reasonable and scalable to what we're talking about in terms of the size of your organization. Typically, PHI is representative of a patient. So the definition of a patient is what we are typically comfortable with in most medical practices, as well as under HIPAA, a concept called a personal representative. A personal representative is a HIPAA term, and that term is designated for anybody who has the legal authority to represent the patient, such as a legal guardian, a parent, somebody who's been provided guardianship, trustee that's been given guardianship for acts of a younger person, and so forth. And a same-sex spouse could also be considered a personal representative. So actually, when same-sex marriage was legalized, the regulations under HIPAA expanded to ensure that same-sex spouses would be considered personal representatives. Undocumented patients are treated the same as normal patients. So a patient's status in terms of immigration has nothing to do with HIPAA and its applicability. In the case of a deceased patient, especially in California, a beneficiary can be treated as their personal representative, as well as the executor of the estate. Now, in some cases, there are individuals who will not reach the standard of a personal representative. And again, with a personal representative, you typically want to look for some legal documentation or proof that they are a legitimate personal representative. One of those could be a medical power of attorney form. That would be a very good way to do that, or some other kind of document establishing an individual as a personal representative. But the privacy rule allows for a little more flexibility, that a patient can also give verbal permission to discuss their care with somebody else without you having to treat that individual as a personal representative. Or if a patient brings somebody with them continually as a caregiver, you can use your professional judgment to infer that they're able to be part of that patient's care. But if that individual came and requested the entire chart of that patient or more information, you would resist that unless you could actually demonstrate they were a legitimate personal representative. In fact, if you don't have the right permission, take the position of not releasing information to somebody other than the patient. Under HIPAA, a deceased individual's PHI must be protected for up to 50 years after the date of their death. That doesn't mean that you can't do chart audits and chart purging, electronic or otherwise, but for as long as you have PHI, it must be protected. And you can share minimal amount of information to those individuals who may not be personal representatives, but were involved in the patient's care or payment for care prior to their death. Prior to their death, if you do not know of a preference to the contrary. Now, what are a subject individual's rights under HIPAA? Individuals have a set of rights under HIPAA. The first and most important is the right to receive a notice of privacy practices. That is a very critical right. It actually replaces any need for a patient consent. Patient consents are necessary for consent to treatment, but are not necessary for HIPAA. HIPAA requires that you use your best effort to obtain an acknowledgement that the patient has been provided a notice of privacy practices. Patients have the right to restrict their information and to request that you restrict how that information is used or disclosed. For example, a patient can request a restriction on a disclosure to the health plan that covers them, and you have to honor that, provided the patient pays you in full for the service that you are rendering. Patients have the right to access their PHI. That means either inspect or copy. Patients have the right to do that within a certain time frame, and California law makes that time frame even shorter. So patients have the right to get a copy within 15 days. You cannot create unreasonable barriers to a patient getting access to their information. In fact, if a patient is disabled or unable to come to your office, you must accommodate the patient in a reasonable way to get them their information. So for example, if you have a policy to say, well, we'll only release information to a patient if they sign a form, that could be considered a barrier. And you may have to give that process up to a patient that's unable to come in and sign a form in a timely manner. Patients also have the right to request amendments of their protected health information if they believe it's incorrect. In California, you can say, well, we think our information's right. And the patient can then say, well, I still think it's wrong. And California law requires that you allow the patient to add a 250-word amendment request and amendment denial to their record, meaning if they disagree with what you have said by your assertion that the amendment, or rather the information, is correct, the patient has the right to say, please add my disagreement to my medical record. The patient also has the right to say, don't call me at home to remind me of appointments, or don't contact me this way in terms of billing. They have the right to ask for an alternative communication channel. You cannot tell them that that is not okay. You must, if it's reasonable, allow and support that alternative communication channel. The patient also has the right to, for up to 6 years, get a listing of all accounting of disclosures of their PHI, except for those disclosures that are related to their treatment, payment for their treatment, your normal healthcare operations, or where they have authorized a release. And finally, patients have the right to complain. In fact, this is very, very important that you do not retaliate or intimidate any patient who wants to complain about how you've handled their privacy. Now, this isn't about complaining about your care. This isn't about complaining about how long it took to get in to see you. This is a patient complaint related to the privacy and how you have used and disclosed their PHI. A little bit more on the Notice of Privacy Practices. Please be sure you all have these and you're handing them out to new patients. It describes how you use and disclose PHI. It requires the disclosures by law that be stated. It tells the patient about their rights. It names the privacy official. And it tells them how to complain. The notice must be posted in a prominent place if you maintain a physical site of service or delivery, typical medical office. It must be given to the patient in the form of a copy if they request it. And you need to use your best effort to obtain a written acknowledgement that the patient has received the notice. Not that they agree with it, just that they received it. And it should be posted at all of your treating locations if you have more than one office. The notice does not need to be given to the patient every year. It does not need to be given with every visit, just initially. If the patient refuses to sign the acknowledgement, you use your best effort, you document that, you continue to treat. If you have a website, please be sure you're posting your current notice on the website. If you revise your notice, simply update and use the new notice as the one that is given to new patients, and replace all the posted versions with that. A revised notice does not need to be given to patients after it's been revised unless they request it. However, it does need to be given as the new version to all of your new patients, initially, one time only. Now, in addition to notices as the way you will use or disclose patient PHI, a key concept under HIPAA privacy is that of authorizations. Any use or disclosure that's not covered in the notice or for public purposes typically requires a HIPAA authorization form signed by the patient. So a patient requesting access to their own PHI is not the type of request that needs an authorization. That's patient's own information. But a patient asking that you disclose their information to a life insurance company would typically be something that you would want to get the patient's authorization for. Releasing records to another provider, however, is not considered something requiring a patient authorization because under the Notice of Privacy Practices, you tell the patient that typically you will disclose their PHI to other treating providers for continuity of care and good care coordination. The privacy rule also has some very basic safeguards that we see further in the security rule. Administrative safeguards like policies and procedures that restrict access to PHI, physical safeguards to be sure that PHI is kept safe in your office, and technical safeguards to keep your computing systems safe from viruses and other systems that might corrupt them. Privacy has a very core concept called the minimum necessary rule. It's a critical concept to be aware of. The minimum necessary rule is an essential part of the privacy rule that extends to the reality of ensuring that you only ask for the minimal amount of PHI and you only release the minimal amount of PHI in how you conduct business. Now, this would not apply to when you are working with another provider. In that case, you want to share all the information necessary to be sure that the patient's care is properly given. On the other hand, if an insurance company is seeking the entire patient chart, you would use minimum necessary to determine whether or not they should get the entire chart or just an abstract that is relevant to what they are requesting. Remember to use caution whenever verbally communicating. Be very careful that you are not sharing information with a spouse, a child, a friend about any patient, and be very careful about taking any PHI off-site unless it is secured, whether it be in paper form, whether it be in computer form. In fact, there is one case of a medical practice paying a substantial settlement to a fine by the Office for the Civil Rights because of a USB thumb drive that was left in their car and stolen, and that thumb drive had patient data on it. So be very careful with all PHI that would leave the office. Verification of identity is another key concept within the privacy rule. It's important and required that you would verify the identity and the authority of anybody requesting access to PHI. So for example, if it's a government individual, you want to verify their authority to request and get such information, and then verify the identity, perhaps get a badge number, require proof on a letterhead, or something of that nature in order to know that you are releasing your patient's PHI correctly to the right person. And HIPAA also has whistleblower protections. In fact, California law and HIPAA both have protections for anybody on your staff that believe there is a privacy or other HIPAA violation and wish to complain or rather blow the whistle. You cannot retaliate against them in terms of their job for the fact that they have, quote, blown the whistle on a HIPAA violation or potential violation. Subpoenas are a common issue with most medical practices. You get them all the time. Attorneys can generate a subpoena, and they have the weight of law, but you do need to confirm when you get a subpoena that the patient has correctly been advised and that the patient, if it's for your patient, has signed off an authorization or a release that you can see within that subpoena. On the other hand, a court order signed by a judge or court subpoena must be followed as it is stated. Always be sure the individual has the right legal custody or guardianship when you get a request from a patient, parent, or personal representative. And under HIPAA, you have a duty to not disclose PHI if it might endanger the patient or cause harm. Now, these decisions can be appealed and internally reviewed. Remember, you have a lot of resources to help you understand these areas. First of all, the Ventura County Medical Association and CMA have many HIPAA materials that we at Private Plan have helped them put together. You can also call the California Medical Association's legal department. You can also check in with your professional liability carrier, who often has great resources on understanding the proper way to release PHI and handling information. Now we move to HIPAA security. HIPAA security protects PHI just like the privacy rule, but it's much more narrow in its definition by it applying only to electronic PHI. So any kind of PHI that is created, stored, maintained, received, or transmitted electronically. An example could be data from your electronic health record, a Word or Excel file, data from a diagnostic equipment, your emails internally that you share about a patient, getting electronic EOB, billing data, your scanned copies of patient information or your backup tapes, or claims that get transmitted to a clearinghouse such as Infinity or some other clearinghouse, eligibility data, electronic referral authorizations, even electronic prescriptions sent to the pharmacy are examples of ePHI. Under the security rule, you must assure that ePHI is accessible only by authorized people, and it has thus confidentiality. It has not been altered or destroyed, thus it has integrity, and that it is available when needed. Much of HIPAA is just good business practice, keeping computers, laptops, and smartphones secure, physically securing your medical practice, using strong passwords and not posting or sharing those, routinely backing up your data so that you have it available should your computer crash, using secure email and secure texting only, or a patient portal for sharing and sending PHI, keeping your computers free from viruses. And like we talked about in the privacy rule, there are 3 components within the security rule that have subparts underneath them: administrative, policy and procedures, physical, and technical. Now, a brief look into each of these shows that, for example, an administrative safeguard is that you conduct risk or security management. That would incorporate completing a risk analysis. We have a separate webinar for you to listen to that talks a lot about MIPS and the risk analysis program. Risk management: if you have a risk, what is your corrective action to reduce that risk? Sanctions for employees who violate HIPAA security. Reviewing your information systems and computers to find out who's accessed them, what they did, and when did they do it. And like the privacy rule, assigning responsibility. In the case of the security rule, this would be for a HIPAA security official. It also requires workforce security, such as supervision, good termination procedures to ensure that individuals have had their access disabled once they have left your employ, appropriate workforce clearance to be sure that the individuals you have hired are trustworthy enough to access PHI, and access management, authorizing use to people only based upon their job description. So for example, under access management, you wouldn't want to give a front desk person necessarily access to everything within your electronic health record, especially if you have a larger practice. Now, in smaller practices, many times everybody has to do every job, and you have a broader job description. But access management would be to set up roles and permission levels within your electronic record or within your practice management system. Providing ongoing security awareness and training. So the privacy rule has a training requirement that you would train your workforce on the privacy rule, particularly your policies and procedures. The security rule, however, requires that you do security awareness and training, and that incorporates periodic reminders to remind your staff about proper HIPAA security, also to remind and keep awareness strong about not sharing passwords, using strong passwords, protecting computers, and so forth. Within the administrative safeguards, there are also specific computer, internet, email policies you may put in place, either for remote access or otherwise. And very importantly, having a process in place for understanding if you have a security incident, how to report that, and how to respond to that. Also, under the administrative safeguards under the HIPAA security rule, is to have a contingency plan to recover data, in particular PHI, and restore your operations during a disaster, if a computer breaks, and so forth. So many of you, I'm sure, have become all too familiar with this through the recent fires and floods in Ventura County, and that your offices could have become very vulnerable to destruction. Having your PHI available and accessible off-site would be a critical component of your own contingency or disaster recovery program. Physical safeguards are the next big class of safeguards. Maintaining a security plan, having doors that lock, having visitor access control, having potentially name badges for your staff so people know they're appropriate to be there, and so forth. Protecting your workstations from being seen by unauthorized people or by bystanders. And securely transporting laptops, smartphones, not leaving computers unattended, and logging them off when you get up and move away from your workstation, a critical part of the HIPAA physical security rule. Making sure your devices and media are properly wiped before you dispose of them or before you reuse them. Now, the next level are things we're more familiar with from the security rule, such as having a password or a username. But encryption is also a primary component within HIPAA. Typically, you need to have either encryption or an alternative mechanism to ensure that data can only be accessed by those who have, if you will, the right key or authorization to see that information. Additionally, under the technical safeguards, you must periodically audit the access to PHI to be sure it's been done appropriately and by the authorized individuals. Transmission security: never send any PHI unless it has been properly encrypted. Now, there is one exception in the HIPAA privacy rule. The privacy rule lets you send unencrypted PHI to the patient or a third party on their request or at their request if they have been advised of the risks of using unsecure email or other means to send that electronic PHI. If they have been so advised, you are permitted, you're not required, but you are permitted to transmit that to the patient or somebody of their choice unencrypted. But mostly we want you to use secure methods for all kinds of PHI, be it email, texting be done secure, or transmitting data, and preferably if your EHR has a patient portal, which for all of you that are participating in your accountable care organization, under promoting interoperability, it must have a secure messaging and portal capability. Use the portal wherever you can, and then let the patient use that data to exchange it with somebody else. Now, there's another concept that is like privacy and like security, and it's a third component of the HIPAA privacy and security rule known as the breach notification rule. This rule requires that there be a specific process and notification done if you determine that there has been a breach of unsecured PHI. And that is unsecured PHI that has been or is reasonably believed to have been assessed, acquired, or disclosed. The breach rule actually defined the term unsecured PHI. And unsecured PHI is basically PHI that has not been rendered unusable, unreadable, or indecipherable. So for example, if you have one of those old linear or strip shredders that you put your paper PHI into, and they produce a very wide strip that could be reassembled and having patient information available to somebody. And then you put that into the trash. That could be considered a violation and a potential breach because that PHI has not been rendered unusable, unreadable, or indecipherable. Or let's say you decide to give a computer away, an old computer, workstation, but you've given away, but you have not wiped it. You've not properly disposed of all the PHI on that computer hard drive. That could be considered another HIPAA violation. Under the breach notification rule, discovery, the time at which the clock starts ticking for when you have to analyze the breach and then determine and notify both the government and patients, starts when you discover that breach. And you must promptly notify, and without delay, and in no case longer than 60 days after discovery. So a lot of elements within the breach notification rule. If you do have a breach, please reach out for assistance to help understand and how to handle the breach. You must act quickly. You must go through investigative steps and determine, was the breach to an accepted party? For example, by mistake, you sent PHI data to another person in your organization. They didn't keep it. It was an exception. That's what we call an unintentional acquisition. So for example, maybe you were planning to send information to a billing person in your office, but instead you chose the wrong email address and it went to a business associate. But that business associate normally does get access to your PHI because of what they do. Then you can follow this particular guideline to determine, all right, this is an accepted circumstance or breach. Or it might have been an inadvertent disclosure, where you disclosed it to somebody who's authorized to have access to that information inadvertently. Or finally, a good faith belief that that PHI has not been or will not reasonably been retained. This is probably the most common exception that you have. This occurs when you inadvertently send a fax to the wrong provider with PHI. If that provider calls you back and you get confirmation that they're destroying properly that PHI, returning it to you immediately, that does not have to be considered a breach if you have that good faith belief. But in most other cases, after you've gone through these exceptions, you'll have to determine and go through what we call a 4-factor risk assessment as shown in this particular slide to determine, based on this information, whether the information that you provided unsecured represents more than a low probability that that patient's privacy has been breached. And if that is the case, you'll have to potentially notify the Office for Civil Rights, potentially the Office of Attorney General, state of California, depending on how many people have been breached, and so forth. So this ends our HIPAA privacy, security, and breach notification basic HIPAA training program. Thank you.